You're watching The Legal Breakdown. So we've got a last-minute Hail Mary play here by Georgia prosecutors in Donald Trump's criminal conviction down in Fulton County, Georgia. But first, just a quick reminder that Glenn and I will be doing daily coverage of all of Trump's prosecutions, including the one happening in Georgia. So if you want to follow along, please make sure to subscribe to both of our channels. Okay, Glenn, back to the Fulton County case and this Hail Mary play. Walk us through what just happened.
Brian, I didn't have this one on my bingo card. Fani Willis, the district attorney down in Fulton County, who's heading up Donald Trump's RICO prosecution, just filed a motion with the Georgia Appeals Court. Here is the title of the motion: Motion to dismiss appeal as improvidently granted. Okay, that's some legal word salad. What does it mean? Well, I read through the 17-page motion, and in essence, here is what District Attorney Willis has just argued to the appeals court. They said, look, we don't think you should have accepted review of this issue on appeal at all. Of course, the issue was, is District Attorney Willis disqualified, conflicted out of continuing to head up the RICO prosecution in Georgia? Judge McAfee said, absolutely not. He said, well, there's a little bit of an appearance concern, so what I'm going to do is give her the option of either taking herself off the case or the special counsel that she hired, with whom she had a personal relationship for a period of time, Nathan Wade, he can remove himself from the case. That will do away with any appearance problem, and DA Willis can continue to head up the prosecution. Well, Donald Trump and the 6 or 7 other defendants who joined that motion appealed Judge McAfee's decision, saying Fani Willis could continue to head up the case. And the Georgia Court of Appeals accepted that discretionary appeal for review. They didn't have to accept it. Well, now, Fani Willis has filed a motion basically asking for a do-over, right? This is like what we would call a motion to reconsider a decision that has already been made. She said, look, based on Judge McAfee's findings and his conclusions, there is really no issue for the appeals court to even take up. And here's how she argues it. She says, when a case goes up on appeal, there are 2 things that the appellate court must accept. And this is universal in all criminal justice systems. They must accept the credibility findings of the trial court judge. Why? Because only the trial court judge was in a position to view the testimony of the witnesses and make those all-important credibility findings, and Judge McAfee did that. And 2, any finding of fact based in part on how the witnesses testified, their credibility, any finding of fact that Judge McAfee made, the appellate court must completely defer to it. They must accept it unless it is without record support. In other words, if Judge McAfee completely went rogue and started making factual findings with no testimony supporting them, which he didn't, DA Willis argued that given those 2 principles of appellate litigation, there is literally no legal issue on the table for the Court of Appeals to decide. I think it's a fair argument. Now, is it a winning argument? What I will say, Brian, is once an appeals court has decided to accept a case for review, you can certainly file a motion for them to reconsider that decision. I think there's a low likelihood of success. And you started out by saying it's a Hail Mary. I think it is a bit of a Hail Mary pass, but it is one that could be caught in the end zone, and it could be a game changer. Part of the problem here, and perhaps even part of what's driving DA Willis's decision to kind of throw this Hail Mary pass, is that the appeals court, for goodness sake, said, we'll accept review of the case, but we're not going to get around to it until maybe October, and who knows, we may not even decide it until March 2025. That, in my opinion, is an abomination, because that is so derailing the notion of a speedy and timely trial down in Georgia that it really does a disservice to the cause of justice. That might be part of what motivated DA Willis to file this unusual motion.
Just so I understand here, Glenn, so the Georgia Appeals Court accepted review, and now the same people who obviously saw enough of a rationale to accept the appeal have to decide that there wasn't enough grounds to take the appeal? Like, does the fact that they accepted it mean that they're less likely to then refuse to hear the appeal under these new grounds?
Yeah, I think it's not terribly likely they will reverse course. But here's the thing, Brian. Courts, do reconsider their rulings, their findings, their decisions, not infrequently. The reason I say that is because a standard part of our criminal practice, I was a prosecutor for 30 years, is filing motions to reconsider when a ruling has been made. But you know what? The party believes that maybe we didn't present all of the evidence or arguments that we should have presented, or maybe there is some case law that we didn't include in our brief or in our argument the first time around. So motions to reconsider are an accepted part of criminal litigation, and that is, in essence, what this is. This is not something that is lawless. It's not something that is frivolous, or worse, that is filed in bad faith. It may be a bit of a Hail Mary, but I think based on the way she framed the arguments, that the credibility determinations have been made by Judge McAfee, that the factual findings that were entered by Judge McAfee were completely supported by the evidence of record, and there is no legal issue if you accept those credibility determinations and those findings of fact, as you must. There's no legal issue to revisit here. I think it's a straight-faced argument, maybe even a somewhat persuasive argument, but I'm not sure it's going to be a winning argument.
Well, I don't doubt the persuasiveness of the argument from the prosecutor's end, but I'm going to channel my inner cynic here and tell me if I'm way off base. But there is a part of me that believes that the Georgia Appeals Court, well, not only took this appeal up, but then agreed to hear it not until October and won't even rule on it until spring of 2025, because they were kind of doing Donald Trump's bidding in the sense that they were granting him the delay that he's seeking. If those people are acting in bad faith by virtue of giving him that delay and perpetuating these dilatory tactics, wouldn't they then be less likely to rule in prosecutors' favor because this wasn't being done for the right reasons anyway?
Sure. If they're acting in bad faith, a la, Justice Clarence Thomas or Justice Samuel Alito, then this is really a hopeless endeavor. But I don't know.
Do you think that's a fair? Do you think that's a fair read, or is it just that the appeals process takes a long time anyway? Am I being too cynical by thinking that the reason that it's going to be so far out, that we're not going to hear this, that this case isn't going to be heard until October and then not ruled on until March of 25, is that me being too cynical, or do you think that there is a little bit of unethical behavior that could be going on that we would have such a massive delay?
Yeah, metaphysically anything's possible, but I am not prepared to say that under sort of the facts and circumstances as we know them, I don't think we can leap to the conclusion that there's anything nefarious going on in the Georgia Court of Appeals. Okay. I don't know enough to reach that conclusion. I think it's smart to be cynical and to be critical of everything we see when it comes to litigation involving Donald Trump.
I couldn't possibly imagine why you would say that.
Look at Judge Cannon, look at the Supreme Court. We have really struggled mightily as a criminal justice system in multiple jurisdictions when Donald Trump is, when there's an endeavor to hold him to account for his crimes. But here's the thing I'll say, the more I've heard about the Georgia system, things can take a very long time, and even in the ordinary course of business, in a case that does not involve a high-profile defendant. So, yes, It is kind of obscenely long for an appeals court in a case where time is clearly of the essence to say, we'll get around to an argument in October and maybe we'll decide the case in the spring. As I say, that's an abomination. And that's something, Brian, that I have to say, when we look back on this sad chapter of our American history, I hope we will learn some lessons about how the appeals courts need to do better. I've argued for accelerated courts for years now. There's no reason an appellate court can't accept a case for review, give the parties 2 weeks to submit briefs. 2 weeks from that, you will argue, and 2 weeks after the argument, you will have our ruling. That is something that I think our democracy needs to see reformed.
Yeah, couldn't agree more. Glenn, let's finish off with this. let's say, for example, let's put the cynic in me aside and say, for example, that the appeals court does side with prosecutors and does basically reconsider their decision to take this issue up on appeal, and the issue goes back to the trial court. Would this trial immediately be back on track, and could it actually move forward before the election? At least the first tranche of defendants that Fani Willis would opt to bring forward.
Yeah, the minute the case is returned to the trial court, to Judge McAfee and to District Attorney Willis, I suspect the next thing you would see DA Willis file is a motion to set a trial date. And, there are still a lot of defendants left. I believe 15 of the 19 charged co-defendants are still pending trial. 4 pleaded guilty and are cooperating with the prosecutors. So I could see DA Willis saying, listen, we're going to batch together 4, 5, 6 defendants. We're going to propose a trial date as early as, August or September. And then it's up to Judge McAfee to see whether that is realistic and whether the defendants can be expected to be prepared to go to trial and go to trial on that date. And don't forget, way back when, Fani Willis did propose an August 2nd trial date. That, of course, was never set. But, at least in the back of their minds, the defense attorneys should know, well, that's something that has at least been kicking around for quite some time. So if the case goes back from the appeals court to the trial court, then I would expect we would see some kind of a trial date set. How far off into the future? That's anybody's guess.
Yeah, and I hope that prosecutors would look at that and look at the extent to which Donald Trump is trying to abuse the system with these dilatory tactics and kind of say, like, okay, if we don't get this thing on a trial track right now, he's going to keep abusing this process until the ends of the earth. So hopefully, if they are granted this motion, as unlikely as it may be, if they're granted this motion to undo this appeal, that kind of serves as the kick in the ass that they might need to then, get their ducks in a row and move this thing on the trial track as soon as possible. Of course, we'll stay on top of this, so as soon as we have any updates, we'll make sure to bring them to you. With that said, if you're not subscribed to both of our channels, please make sure to subscribe. The links are right here on this screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.